We'll get started. My name is Charles Gauthier. I'm the President and CEO of the Downtown Vancouver Business Improvement Association. And welcome to our weekly webinar series, DVBI Members Helping Members. We're so glad you could join us online today. Before we jump into our content, I'll let you know that you can submit your questions in writing today via the Q&A feature at the bottom of the Zoom window. I was speaking with Danya just before we started today, and she'll take some breaks during her presentation to answer any questions. And so if you've been on our webinar series before, we typically wait till the end for questions, but we're going to do a little bit differently this time. So if there's something that you have a question about that has come about as something in our presentation, I would suggest posting it sooner. And that'll be a great opportunity for us when we take, I think we said 2 or 3 breaks during the presentation. And we can pause there and then we can take some questions, and I'll be reading those questions. So again, just encouraging you to post them in the Q&A box. So let's start the programming. Today's topic is presented in partnership with our friends at Boughton Law, and we'll cover some of the legal considerations for operating your business online. Leading our programming and answering your most pressing questions will be Boughton Law's own Danya Bahati. Danya is a corporate, commercial, and intellectual property lawyer. As part of her corporate commercial practice, she assists her clients with corporate governance, negotiation, and preparation of contracts. As part of her intellectual property practice, she supports her clients with brand strategy and protection, e-commerce, social media marketing, and copyright and trademark protection. Now, well, without further delay, I'll hand it over to her to get us started. Take it away.
Thanks, Charles. So I just want to make sure everybody can hear me. Yeah, I think I'm seeing some people nodding, so that's great. Well, first off, thank you so much for having me. I really appreciate everybody taking some time out of their day to hear me speak on this topic. Charles, thank you so much for the introduction too, because I was going to talk a little bit about myself, but now I guess I don't have to, which is always good. But just to kind of draw on what you were saying, Charles, and just to give a little bit more background to everybody that's here on the call today, or on the Zoom session, I should say. What we're going to talk about today, it's about taking your business online, but it's also very much related to the impacts of COVID-19. And it kind of is interesting because this is something that I've practiced over the last several years. I typically help my clients who are already on, conducting an e-commerce kind of platform with respect to their business. And then, of course, I help a lot of my small business clients don't operate online. And so they'll come to me when they're kind of ready to take things online and to kind of help get them set up with an e-commerce platform. What we've seen over the last, of course, 10 weeks is a huge surge in small businesses, larger businesses really pivoting and transitioning to online, but as a pure reaction to COVID-19 and of course the shutdown of non-essential services. So I found myself very busy over the last 10 weeks kind of trying to help my potential clients and existing clients that really had not already done this in the past. And that's kind of balanced with the individuals who were already doing that. And so we thought, this is a really good time to sit down and talk about this. And I often find myself presenting on this very topic because this is what people really want to talk about. And now is a very particularly interesting time because we're starting to see, I guess they're calling it phase 2. Some of the non-essential businesses are now starting to reopen, and we'll talk a little bit about that and how that is also kind of playing into the whole mix. So without further ado, I think we can go ahead and get started. And so, of course, I have to start off with a disclaimer. This is not tailored legal advice or legal advice at all to anybody who's attending the call. This is just, the purpose is to be purely informational and to kind of get this idea, kind of getting it activated in your minds. And so people can start thinking about this, or if you've already thought about this, then this presentation really is going to just give you some really hot topics and some basics on how to move forward. And hopefully it's going to answer a lot of questions that you already had, or maybe it'll strike some new questions that you may have that will result from this presentation. So if you do decide in the future, or if any of you are here in kind of an advisory role, or if you have clients who are thinking about taking their businesses online, then of course you want to always consult with a lawyer who has expertise in this field so that they can direct you in the right direction. And I think you probably know a little bit about Boughton, but of course we're a full service firm. I myself practice in corporate commercial and intellectual property, but we have a wide array of services that we offer. But I won't take up too much of your time talking about that. So I think we should just step right into it. As we all know, about 10 weeks ago, maybe more now, might have been 11 weeks ago, there was a shutdown of non-essential services because of course, COVID-19. And so what that did was it made two things very clear. So a lot of the regular businesses that we were all used to using were now shut down. And of course, we all had to kind of keep in mind that social and physical distancing are basically the new normal. And of course, it's no surprise that that had a huge financial and economic impact on small businesses. Of course, let's just focus on BC, but all over the world. And so businesses had to start implementing very creative ways to stay connected. I think what's really interesting is that the businesses started going online just to stay connected to their customers rather than even selling goods and services online. I think that kind of came after just the pure purpose of staying connected to individuals. And I think we all saw that when we would either, turn on, your LinkedIn or your Facebook or social media, you're now seeing yourself connected to all these businesses that you would frequent. So that's interesting, and that's very important because it kind of goes to my point that I'll discuss later on. But even if you're not selling goods and services online, if you're connecting with your customers online or with anybody online, then what we're going to talk about today is going to impact those small businesses, even if their businesses haven't actually transferred online. So even if it's just a method of communication, but we'll touch on that too. And so I thought it would be helpful just to kind of touch on whether or not this applies. And I just want to, again, emphasize that, of course, this is going to apply to you if you're selling goods and services online. It's also going to apply to you if you're just merely advertising online. Certainly, it's going to apply if your business has a social media account or anything from Facebook to Twitter to Instagram. It's going to apply. And if you just simply have kind of a informational website that doesn't require anything other than your customers visiting the website, or even non-customers visiting the website. So this is a pretty broad group. And you can probably be very confident that the issues we're going to talk about today, i.e. the terms of service and the privacy policy, are likely going to impact your business. So I thought it would be helpful to just breathe some life into these examples I keep talking about. I remember when the pandemic started to kind of shift our reality, I started seeing restaurants that typically don't do this now are starting to offer takeout services and meal kits. Chain restaurants that are now essentially turning themselves into a grocery store where you can actually order groceries. I saw a lot of fitness studios that started offering online and virtual classes, a lot of those classes being free. And then later on, of course, I started to see a lot of just fitness studios asking you to pay for the online classes, of course, but again, that just speaks to the initial phase of everybody trying to stay connected to their clients. We've seen a lot of retail stores, just boutiques that are starting to just sell their goods and services exclusively through an e-commerce platform. And physiotherapists, I myself had a couple physiotherapy sessions where my physiotherapist was actually just telling me what exercises I had to do. So I think these four industries, I've just used them as examples because they're very different from each other. And so when they take their businesses online, just using these as an example, all these four different types of businesses have to take into account different types of laws that apply directly to their business. And that's a huge takeaway from today, is that you know, when you decide to go online, you really have to consider all the different types of laws that may apply to your specific industry. So for example, there's going to be some health regulations involved with the restaurant industry, or health and food or drug administration, or liquor regulations when it comes to restaurants that are offering alcohol delivery or things like that. Physiotherapists, of course, have to make sure that they're complying with their governing bodies. So there's no one size fits all. It's certainly just, as my next slide says, it's just not that simple. Now, our job, of course, is to make it more simple for you, and, you know, to try to make this kind of as digestible as possible, and to kind of put together a package for you to assist you in going online. So we just talked about the fact that there's going to be differences depending on what industry you're in. And I don't want to overwhelm anybody. So let's, you know, get it back to basics and talk about, well, okay, we know there's going to be all these different laws that are going to apply, but what at least is going to be consistent? What are the two things that you should really be taking into account if you're taking your business online? And so, of course, these are the two hot topics we're going to talk about. There's going to be two things that each business owner should know when they go online. They need to know that they need to implement a terms of use. We're going to spend half our time today talking about what that is and what's included in a terms of use. And businesses need to absolutely implement a privacy policy. And we're going to spend the other half talking about the privacy policy. And so these two, let's just call them documents, because that's essentially how they're going to be presented to your customers or to your website users. These two documents go hand in hand in the sense that you need them both, and each of the documents are going to refer to each other, but they serve completely different purposes. And they're really there to, I would say the terms of use is really there to protect the business, because it allows you as a business owner to really set out, you know, the terms and conditions that you are offering and for your customers or website users. And, you know, it's basically like, here are my terms and conditions. If you want to be a customer, you have to comply with these. That's kind of the purpose of the terms of use. And then the privacy policy, I would say, is really there to protect your customers or your website users. So that privacy policy is extremely important, because privacy laws in Canada are extremely stringent, and they require all businesses who have a website or have any kind of online presence. They also apply to non-online presence businesses, but if you're going online, you have to post a privacy policy on your website. So we'll talk more about that towards the second half. So for now, let's just focus on the terms of use. So just to start off though, terms of use is also referred to as terms of service, terms and conditions. I've even seen end user agreement and things like that. So there's a lot of different terms that are being kind of thrown around out there, but they all, for the most part, look the same. And typically when you go on a website, we're all probably very familiar with terms of use, because, you know, as consumers and as website users ourselves, we see them all the time. And typically they're buried at the bottom of a screen or at the bottom of a website. It's a tiny little link and it says terms of use, and typically there's a privacy policy link right next to it. And I have a lot of views on that myself, because there's a lot that goes into whether or not these terms of use are actually enforceable. You know, if they're buried at the bottom of a page and the presumption is that people don't actually read them, then you as a business owner are going to have a lot of responsibility to make sure that you're doing everything you can to direct the attention of your customers to your terms of use. So I think it's safe to say that everybody knows generally what they are, but if you don't, they're typically just the fine print, as I like to call it, that is buried away at the bottom of a website. Now, the purpose of the terms of use is to govern the relationship between you as a business or a business owner and your website users or your customers. So essentially, it's supposed to operate like a contract, except nobody really signs the contract. So we have to consider whether or not just posting the terms of use is sufficient. And I've had to deal with this a number of times. One of the main questions I get is, are electronic signatures required? How do we know that our customers are actually agreeing to our terms of service? And is it enough to just post it, fine print, and just expect them to read it? Them being the customers or the website users. And my response to that is we need to be as proactive as possible when we're posting these terms to our website. So I have a few tips that I think are really helpful in terms of how to make sure that a business owner kind of went out of their way to make sure that the terms of use are enforceable. And I'm going to talk about that in a moment. But first, I want to talk more about what the terms of service actually include, because I think that'll give it more context. So typically, terms of service, again, depending on the, or the terms of use, depending on the industry, just from a very broad level, typically they should describe the goods and services. They should include payment terms. So things like pricing, things like currency. So we charge all our goods and services should be charged in Canadian dollars, for example, versus US dollars or any other currency. There should be terms about customer complaints and your refund policy. Those should certainly be included. Shipping delays and what would happen if, for example, you're shipping goods and services and they might be delayed. Intellectual property protection is big, because the second you start to operate a kind of an e-commerce platform or take your business online, I'm going to assume that there's going to be some branding involved. And so you might have, images of your trademarks or your branding, or you might even have links to third-party materials. If you're a retail business, for example, or if you're in the food industry and there's, other products that you are promoting on your website. So you need to make it very clear as to whether or not you own certain intellectual property that's embedded in the website, and you have a responsibility to also notify your customers and website users that, this intellectual property is protected. You have to tell them that they're prohibited from copy and pasting content from your website, especially if you're posting third-party materials that you hopefully have a right to do. So that, there's a wide array of issues that fall under the intellectual property provisions. One thing that's definitely mandatory is you have to reference your privacy policy. So remember that the terms of use and the privacy policy are two completely separate documents, but they go hand in hand. So they have to be referencing one another, and you should also embed a link in your terms of use. When you're referencing the privacy policy, you should be embedding a link so that users can click on it. And these are rules that have been discussed, at the Supreme Court of Canada level. So judges have actually considered how do we ensure that business owners are actually complying with these, with just general contract law and directing customers to specific websites. Well, you have to embed the links. So that's very key. Limitation of liability is probably one of the most important things you'd see in a terms of use, because it really sets out how the business would likely want to limit their liability. So something I read recently in a terms of use that I was working on was one of my clients sells clothing, and they really wanted to make sure that a specific textile that they were using has been found potentially to cause rashes. So they want to make sure that, if you have the skin condition, then you shouldn't buy our products. And if you do anyway, we're limiting our liability. So little things like that. And that's limitation of liability is really, it has to be very tailored and customized to your industry. So, food industry is going to have different obligations there. And if you're in the business of delivering alcohol, there needs to be some comprehensive limitation of liability there, and so on and so forth. So there's going to be a lot of different considerations to take into account when it comes to that. And governing law. So assuming that business owners or everybody on this call is based in BC, of course, Vancouver, but really making sure that you have that set out in your terms of use, that any disputes that might arise are going to have to be governed by a specific jurisdiction. And for us, we're going to just assume it's BC. This is really important. I've seen some clients have come to me because they've accidentally used another terms of use. We're going to talk a lot about that too. And they didn't read it carefully, and maybe there was a governing law provision in there that said the state of Delaware because they copy and pasted terms of use. And so you really don't want to end up in a situation where you're not litigating disputes. Hopefully there will be no litigation, but where you're kind of promising to litigate disputes elsewhere. So those are kind of the hot topics under the terms of use. And this, actually, the next slide just segues into what I was just talking about. So one size does not fit all. You cannot, or you shouldn't, copy and paste terms of use from a website and think that that is the terms of use that you should use for yours. Because well, of course, there's going to be differences between industries, but let's just assume you found an industry that is similar to yours. And so you think, okay, well, they've taken into account all these things that I should be taking into account. I think I'll just use theirs. I think we need to keep in mind right now that given the financial and economic impacts of COVID-19, a lot of business owners, rightfully so, may not want to spend legal dollars on, setting up a terms of use or a privacy policy. So a lot of people are just kind of doing what they can, doing the best they can, and maybe copy and pasting terms of use onto their websites. I've seen a lot of that for sure. But I think it's important to understand what the risk is there. And the risk is that that document was not drafted for your business. Maybe they have a different refund policy, maybe they have a different shipping policy. Maybe that that specific business has customers in Europe. And so they've taken into account all these regulations that actually wouldn't apply to your specific business. So just like any other contract, you really want to make sure that it reflects the business's intentions and that it also takes into account all the applicable laws that you might not be aware even apply. And so we talked a little bit about the next points on the slide, so I will skip that, but it's just important to note that you really want to make sure you are having a customized terms of use built specifically for your business. One other point that we didn't discuss, this kind of is a hybrid point. It falls within the scope of a terms of use and a privacy policy. It's this concept of targeted advertising. You probably all realize that when you log into, Google or you're just on your computer, you're probably seeing a lot of ads that are targeted to your search history, that are targeted to your personal preferences. There's a lot of just audio targeted advertising going on these days. And so this is interesting because a lot of terms of use, even 5 years ago, did not address this issue. But now, as a business owner, if you are using specific tools like Google Analytics is something that comes to mind, your website developer is going to have more information on this. But if you are, as a website, if your website is, has cookies or technology tracking devices that will engage in targeted advertising, then that is something you certainly need to notify your customers about, or even just your website users. So again, keep in mind, anybody who visits your website needs to know that maybe there's some targeted advertising going on, and your responsibility is simply to notify. And this also, like I said, it's a hybrid point, so it falls within privacy as well. And that's because, well, if you think about it, targeted advertising really is another form of collecting information, but for the purpose of advertising and behavioral tracking. And so we won't get into this too much today because it does seem to get pretty technical, but what you should take away is that if your website developer, you need to make sure that you understand exactly what kind of tools they're setting up for your website. And if there's any type of targeted advertising, then you need to notify your lawyer, and then your lawyer will make sure that the correct provisions are in your terms of use. And of course, also in the privacy policy. we did talk about governing law and it being in BC, and the only reason I bring it up again in these slides is because I did want to just mention that for many of you, it's difficult. When you go online, you all of a sudden are accessible by a lot of different people in a lot of different states and jurisdictions and territories. So you want to make sure that you're very clear and transparent with your clients as to whether or not you even offer certain goods and services to other jurisdictions. Some provinces are going to have different definitions just within Canada as to the age of majority, for example. So typically how you deal with this in your terms of use is you need to tell your lawyer, or you need to consider what provinces, let's just keep it to Canada for now. So what provinces in Canada are basically subject to these terms and conditions? Are you going to be delivering goods and services all the way over to Ontario, for example? And if so, you need to make sure that your lawyer knows that, because there's going to be different implications for different provinces. And sometimes BC lawyers might not have all the answers for the Ontario laws, but we certainly will point out what needs to be addressed. And just in my personal experience, I work very closely with our affiliate offices over Canada. So sometimes it's just a matter of a quick phone call and making sure that, you know, for example, an Ontario lawyer would bless the terms of use and the applicable laws that would apply to your business there. So definitely worth raising. But again, your lawyer will be asking you these questions. And so you won't be forced to remember all of this. Your lawyer will be asking the right questions. And so you just want to make sure that you have considered all these points and that you kind of have a plan prior to going online as to, you know, the global reach or the national reach of your clientele and your business. So we talked, just as a quick summary, we've talked a lot about, you know, what laws are going to apply to your business and what laws do you have to consider. Now, this isn't all on you. Again, your lawyer should be asking these questions, but it's always important to kind of know and to anticipate these questions before you go into preparing a terms of use. So of course, we talked a lot about the type of business and how specific laws will apply to specific industries. And we talked about the location of the business and of course the location of the customers to make sure that, you know, laws that apply in Ontario, for example, will apply to your terms of service if you have customers in Ontario. And I did want to talk about how to make sure these contracts are enforceable. This is something that I personally always encourage. So just to kind of take it back to basics again, we need to think about the terms of use as a contract. It's really just a contract between the business and the website user or the customer. And so you want to make sure that this contract is enforceable, and that if the customer ever complains and says that contract, I didn't really understand what I was getting into, you want to make sure that you've taken all the proactive steps to ensure that as a business owner or as a business, you did what you needed to do to make the contract enforceable. And how you do that is a number of ways. So you really want to avoid legal jargon in your terms of use. And you really want to set out the terms kind of in regular, plain, as much as you can, in regular and plain language. And again, that's where your lawyer will step in and ensure that it's not peppered with legal jargon that is difficult to understand. Now, the next issue is you want to make sure that there's some form of acceptance from your customer. And so the question is, well, when terms of service are just simply fine print and they're buried at the bottom of the page, how can you really trust that your customer either read them, that the website user read them, or that they even know that they're there? And so what I always recommend to my customers, or to my clients, and they don't always love this idea, but I always say, I've personally visited a lot of websites where as soon as I log in, there's a banner at the bottom of the page, kind of just bringing my attention to the fact that it's kind of like a pop-up. So just bringing up the fact that there is a terms of use and a privacy policy. And the reason they're doing that is because, you know, they're trying to show you that, listen, I know you're on this website. I really want to direct your attention to my terms of use because essentially that's a contract between you and I. That's what that's doing. Rather than just burying the terms of service and hoping that maybe you don't read them, or just hoping that, that's the presumption though, nobody reads the terms of service. Another thing I've seen is a pop-up. I think the more onerous the terms of use are, the more you'll see a pop-up or a banner on the side of your screen. Feedback I had from one of my clients this year was that that would be a marketing disaster. He said, I don't want people logging onto my website and having to click a pop-up or be inundated with banners and things like that. So I can understand that that could be a little bit too not so pleasing to the eye and maybe not so user-friendly, but it certainly does protect the business. And so if there's any way, either by way of a smaller banner or placing the terms of use on different links throughout the website, that's all going to protect you more. So I do recommend that. And also, when it comes to acceptance, so that's the first step. So just the first step is directing your customers to the terms of use. The second step is acceptance. Typically, you'll see language that says something along the lines of, if you read these terms of service, and if you continue to use this website, or if you continue to use our services, then you're implying that you are agreeing to my terms of service. So I see a lot of that. Very standard language. I've read it myself as a user. It's not bad, but what would be better would be a scroll wrap agreement. They call it scroll wrap or click wrap. What would be better is to actually have active consent or active acceptance. So I've seen a lot that say click here to accept. And again, if you're going for the gold standard, if you're going for, doing the most that you can to show that you really went out of your way to show your customers your terms of service, then that's definitely the route you want to take. But again, I completely understand that that's going to depend on the type of business, and it's going to depend on your clientele. You might want it to be more user-friendly, but again, there's risks with doing that. So we've talked a lot about everything here. I've kind of gotten a little bit ahead of myself. And I think this is the last leg of the terms of use. So we're going to talk a little bit about consumer protection, not too much, before we take a tiny break, if anybody has any questions about the terms of use. So I've really talked about terms of use as a document, kind of the administrative aspects of a terms of use. I like to call it kind of the admin side. I also want to talk about the purpose behind it, because understanding the purpose behind the terms of use as well also helps understand what consumer protection means, and consumer protection is something you should all be thinking about. And so you, as a business owner who's providing goods and services, you are required to ensure that you are not engaging in any false or misleading advertising. And you also have to meet certain requirements by consumer protection laws to ensure that your customers are walking away with kind of having had engaged in fair marketing practices. And this, of course, applies to any and all transactions that are going to be done online. And you've probably, when you start to learn about it, you start to actually think about your past transactions that you've participated in online, and you'll realize that a lot of these procedures are implemented for a reason. So one thing is, as a business owner, you've probably noticed that all websites have an About Us page. The reason they have that is because consumer protection laws expect business owners to provide information about themselves. Of course, a lot of businesses aren't going to name the name of their legal entity, maybe just a name that they operate as, but the name of your corporate legal entity should also be included, because consumers should have a right to know exactly what company they're dealing with. They should have a right to know that that company actually exists. And so you have to really set out exactly who you are and what your services are about. The reason why terms of service or terms of use are implemented on a website is because consumers have to be able to access that contract before they accept or pay. And they also have to be able to access an order summary, which you'll also see. And now we're kind of entering the world of actually purchasing products online, but that's something that is required. And that's something that if you're using a third-party merchant, for example, or if you're using a third-party service, like a good example is Shopify, then they're going to have these, well, hopefully they're going to have these procedures in place, but it's also important for you to understand what they are as the business owner that's hiring these third parties. You should also have an option. You'll also notice refund policies will be peppered throughout the order process. You have to provide individuals an option to go back and review their orders. And you also have to provide your consumers with a receipt, which can be printed. And you know, one thing you'll notice is email confirmation after the orders is also required. So that actually was a gray area in the past on whether or not email confirmation was always required, and now it certainly is. That's why you probably see them all the time. And then there's the second leg of consumer protection, which is about deceptive or unfair practices. And that's kind of a creature of its own, and I think we've discussed potentially doing a separate presentation on that. But what I want the business owners that are on today's call to take away is that there's a whole different body of lists and regulations for people to comply with when they start advertising online. Social media has obviously completely exploded for businesses, and it's in a good way, I would say. It's definitely allowed businesses to market and really reach a bigger market really when they're advertising online. But there are very specific laws about what you can and cannot do on social media. So what I do want everyone to take away today is that if you're engaging in social media marketing, you really have to think about fair practices in that, and that's something that I can talk about probably another day because we want to focus on privacy in terms of use, but it's just kind of something to take note of. So there's, don't jump into that without consulting with a lawyer. I guess that's what I should say. Okay, so I think we're ready to break on the first half of the presentation, which is terms of use or terms of service, and I think we are on track for time. So if anybody has any questions right now, I'm happy to field those.
Okay, and I do have one question that's been posed. If I'm selling on US Amazon, do I need to pay US local tax and federal tax? Also, what's the tax implication in Canada? Which law should be included in the T&C?
Amazon's a tricky platform because they have their own sets of rules and regulations through their terms of service, which I haven't actually looked at. I had a client who wanted me to look at that, and then they decided not to follow through with Amazon. Typically when you are, I don't want this to apply specifically to the Amazon situation because it's, you know, when you enter into the tax implications, it's, you're going to need specific tax advice. But if you're selling in the US, what the business owner should be aware of is that selling in the US means, of course, the customers in the US are going to have to pay US tax. So the responsibility of the business owner is to ensure that the US taxes are correct, that the amounts are correct, that the jurisdictions are correct, and that those are being charged. Now, when Amazon gets involved, my understanding is that Amazon takes care of that aspect, but I would say exercise caution and make sure that the lawyer that you're dealing with, if so, reviews the terms of service that Amazon provided you with.
Okay. Just maybe a few more and then we can wait till the balance of your presentation. But will a website developer be responsible for creating a terms of use for my website?
No, the answer to that is no, and nor do you want them to create a terms of use for you, because terms of use is really, it's a legal document, and website developers, what they can do with the terms of use is they can, I've worked very closely with website developers for my clients, so my client will come to me and ask for terms of use. I'll draft it, and the website developer will have little things like, okay, we want to have a click to accept option. Can we do that? So of course the website developer will get involved and will provide advice on the different types of technology features that can be implemented. But when it comes to a legal terms of use, again, exercise caution and make sure that you are consulting with legal counsel to do that.
And I think you might have covered this in your presentation. Do clients have to physically sign the privacy policy or the terms of use, or checking a box suffices?
Well, so yes, we did address that in the presentation, but we can definitely go over it quickly again. Checking a box is, I was referring to it as the gold standard, because it's express active acceptance of agreeing to something. The other option is that you just have language in your terms of use or even in your privacy policy that basically says, if you read these, if you use our website, you're agreeing to our terms. And that's not considered really fair. That's what the Canadian courts have said, is they've said, you know, we all know no one's really reading these. So how are we going to deal with that? And so it's not mandatory to have a click to accept, but I typically encourage that because it really protects you as the business owner to say, we really did act proactively. We really did go out of our way to have individuals be notified of our terms.
Okay. Why don't I just hold off on some other questions until the second part of your presentation?
Sure. Should I go ahead?
Yes, go ahead.
Okay, so we finished talking about the terms of use, and now we are going to talk about privacy. Now, privacy laws in Canada, and actually privacy laws in the US and Europe, let's just focus on those three, but really we're focusing on Canada. They are similar in the sense that, you know, Canada has a privacy commissioner and various privacy laws that require any individual or any business that's collecting any kind of personal information, they have to comply with privacy laws. And we're going to talk about the 10 principles of privacy law. We're going to talk about what that means and how you can make sure you're complying. And we're going to talk about why it's important to have a privacy policy on your website. So first off, I should say that this doesn't only apply to online businesses, but again, the second you go online, you have an onus, you have a responsibility to post these documents on your website. And so there's, like I said, there's going to be different situations for your business. There's going to be different specific types of terms you want to include in your privacy policy or your terms of use, but we want to keep it simple. And we're going to speak about this from a broad perspective and just touch on the principles that you'll need to understand and that you'll need to engage with in order to operate your business online. Now, when you're operating online, so like I said, you've got your terms of use at the bottom of the page typically, and you're also going to have a link for your privacy policy, and each of those documents are going to make references to one another. When you have your privacy policy, you'll typically, the user will have to click on it, but I don't want to be repetitive, so I'll just quickly say that if you have the banner or the pop-up that I talked about with respect to the terms of use, that's actually a lot better. But let's say, okay, we're in the privacy policy document now, and what does that actually mean? So the privacy policy sets out, it's almost like a statement to your customers about how you are, as a business, are complying with privacy laws. And we're assuming for the purposes of this presentation that your customers or your website users are based out of Canada. So first step is you have to describe what personal information is, because we keep talking about personal information. What does that really mean? Well, it's important to note that personal information is actually a defined term in Canada under our privacy laws. And it means any information really that is identifiable about an individual. So any information that can be used to identify me. That could include name, email address. It could also include sexual orientation, religion, comments that maybe I've posted on a website that might be linked to me in some way. Really any information that can be used to identify that I'm that person behind the computer. So that's obviously a very broad definition, and that's why you don't actually, your privacy policy doesn't only apply to your customers, it also applies to individuals that just visit your website. And so before you start to collect information about people, and you may not collect much personal information, but I'm going to talk about how you probably will. You need the consent of an individual before that individual starts to engage with your website, starts to engage with your goods and services or your business. And consent of an individual should be able to be withdrawn at any point. So how do we get consent? That's the first step. Okay, well, consent kind of means that you can either, again, have somebody expressly consent by ticking off a box on the website, or you can have the implied consent, which states if you visit the website, this is how we're going to use your personal information. The next step is stating your purpose. So why is it that when you enter the website, we're going to collect personal information from you? So you want to actually set out why it is you need personal information. So maybe, for example, the business needs personal information because they need to ship products. Maybe they need personal information because they need your sizing to sell you certain clothing. Maybe they need your personal information because they need your email address to send you the receipt after. So there's a wide array of reasons why you would need personal information. Maybe I've helped a lot of clients in the tech space who are developing apps. And so they need, for example, geographical GPS location of individuals because their app connects them with with the closest grocery store. Let's say that's just an example. So you have to actually state out what information you need and why it's important to the business providing the services. The next principle is you have to state, and you have to actually follow through with this too, that you're only going to obtain what you need. So if you don't need to know the geological location, if there's no GPS requirement, then you really shouldn't be collecting that information. If you're, again, let's go back to the liquor distribution. So maybe I need to know how old you are, but I certainly don't need to know what sex you are. So to sell alcohol. So little things like that, you have to be very accurate about what information you need, and you need to really make it clear that you're only obtaining the information that you need. The next principle is, if you have a website, people are visiting your website, maybe they're filling out order forms, maybe they're putting in their name, their address, their telephone number, their credit card information. You are responsible as a business to keep that information secure and to prevent unauthorized use or accidental disclosure. And so there are obviously, you might want to make sure that you have cyber insurance, that you have commercial general insurance set up for your business that takes into account potentially a cyber breach. But you also have to set that out to your customers, and you have to basically make them this promise stating that you've implemented industry standard security measures, and then you have to give your clients the opportunity to review that and say, okay, I may or may not want to actually engage with this website because I don't really like their security measures. You also have a duty to respond, this is the next principle, to any inquiries that customers may have. And I'm actually surprised, I actually deal with this one quite a bit. People do read privacy policies and people do have questions about them. And maybe especially, I would say, given the climate over the last several years, the data breaches that have taken place, probably, or the privacy concerns really that have taken place with respect to the US or certain social media channels, people are becoming way more educated about this, and they're going to have questions. So you always have to have somebody that we like to call the privacy officer for your business that can field these questions. Now, I don't want to concern you. You don't actually have to hire somebody specifically for this role. This person can be, this can be any employee or anybody who you've appointed within your business to be the privacy officer, but what you have to be responsible for is to ensure that your privacy officer understands privacy legislation and that can answer questions from concerned customers. Now, another option, of course, is to field those questions to privacy lawyers and just making sure that you have a privacy lawyer who can help you in understanding your customers' concerns before you respond to them. The next two principles about conducting a privacy audit or measuring your practices, these are more preventative procedures that you can take. Often bigger businesses like to engage in privacy audits and they like to review their privacy practices once a year. If you're a smaller business and you just simply don't have the bandwidth for that, one thing you can do is just make sure you're updating your privacy policy once a year. You can kind of leave a note or diarize a note in your calendar to follow up with your privacy lawyer once a year, just to make sure that if there have been any changes to privacy legislation, that you are keeping up to date and that you're keeping a tight privacy policy on your website. So once you've kind of compiled all of this information, then you develop your privacy policy and you post it to your website as kind of a document that states what you're doing to protect the personal information of your customers and of your website users. So there's a lot to unpack there. Some of the things I've seen come up, especially since 2018, has been different jurisdictions like Europe, different territories like Europe, of course, have come out with very strict privacy policies. It's called the GDPR. You've probably maybe heard of it. And the issue there is that sometimes in other places, privacy policies are more strict. And so if your business in Canada and somebody from, let's say, Spain offers or purchases something from your website, and if you're collecting personal information from that person, then all of a sudden the privacy laws of the EU are going to apply to you. And we have, when this first came out, when European privacy laws first came out in 2018, they were amended in 2018, and when they first came out, there was a flurry of activity with individuals who had websites and who had customers overseas. How do we deal with this? We're now subject to these laws and we're not even operating in Europe. We might have some customers there. And so the answer to that question is, we've come up, the way that I deal with this is that I typically like to draft strict privacy policies for my Canadian clients. We have affiliate offices in Europe, and often we'll have one of our European affiliates bless the privacy policy to ensure that it also has legs in Europe, that it also would stand and comply with the European privacy laws. So it sounds like a lot, but there are ways to simplify this process as long as you kind of have the right people involved. But it's just something to take note of. Just be aware that if you have customers in the US or customers in Europe, that you're going to want to comply with their privacy laws too, or you'll have to. So the very last, the last point I wanted to discuss, this certainly doesn't only apply to online businesses, but I thought it kind of fits in nicely, and it will apply to all businesses really, is we call it CASL, but what that stands for is the Canadian Anti-Spam legislation, which was introduced in July of 2014. The purpose of this legislation, CASL, anti-spam, was of course to reduce the amount of spam that we're seeing just generally on our phones, in our inboxes. And so the government of Canada really wanted to step in and make sure that they put a procedure in place so that businesses are not just spamming your inbox. And really the purpose wasn't to limit the freedom of business owners in any way. The purpose was to limit spam. And apparently there's been a huge success with CASL. In the beginning it was kind of tricky, but apparently businesses are finally getting on track. And what I've noticed is I'm constantly getting emails from from businesses that I've engaged with online. And then there's always something called an unsubscribe option. And if there's anything that you take home with you today with respect to the anti-spam legislation, are basically 3 points. Number one is to just think about how you're communicating with your clients. If you're communicating with your clients through a commercial electronic message, which is either an email or a text message or an instant messaging feature, CASL applies to you. So if it applies to you, number two, you have to make sure that you are gaining implicit or explicit consent. We don't have a lot of time to dive into what implicit or explicit would mean, kind of self-explanatory, but let's err on the side of caution and say get explicit consent. Ask your customers whether it's, again, by way of an email or a tick-off feature on your website. You have to ask them if you can send them these messages. And number three, always have an unsubscribe option. So whether it be in a text message, you've probably seen this before where it says, you know, if you want to stop receiving these messages from us, please press 1. Always have an unsubscribe option in your emails as well, which is just a link at the bottom of your email, because this is required. Again, required of all online businesses or non-online businesses. And I will say that the penalties for non-compliance with CASL are extremely significant. If you're an individual, they can range around the $1 million mark. If you're a business, they can be around $10 million. And it's actually, if you visit the CASL website, there's a list of businesses that have run into this problem and have had to pay really large penalties for not complying, even though their intention was never to spam, but their intention was just to communicate with their customers. It's important to follow these guidelines. So I think that actually wraps it up. The second half was a little shorter than the first, but if anybody has any additional questions, I'm happy to field those.
Yeah, I'm not seeing any other questions, Danya, and I want to wrap it up. We've run out of time, but I want to thank you for the hard work you put into this presentation. It shows that you've put that time into it, and I think you could have easily have filled another half hour as of communicating this information. It was very detailed, and I certainly took a lot of takeaways in terms of how we can use this for our own organization. So thanks again for all your time today. We truly appreciate it. And then to the participants today, you'll be receiving a follow-up survey via email this afternoon. We need to hear from you. Hope that you'll find a few moments to fill out the survey and let us know how we did. And we'd also like to hear from you about topics that you'd like us to cover in future webinars. So please let us know. Our next weekly webinar is actually this time next week, 2 p.m. And the topic is store reopenings with our guest presenters from Deloitte. So that's our time for today. Thanks, everyone, and hope you have a nice day.
Thank you. Thanks so much.
Bye-bye.